And we will move back to the Supreme Court. And I realized as I was getting today's slides ready that I never posted Wednesday's slides. So I just combined them and it'll all cover chapter 14. But any questions before we dive in and finish the Supreme Court?
No.
Just a fun little review.
I have a question, Mr. Bean.
Okay.
It's about the project assignment.
Yes.
When are you gonna like have a day where you talk to us about that, or are we just, is it gonna be due all in one day?
No, I will be talking to you every class period about it.
Okay, that's all I needed. Thank you.
Okay. So Monday, when the little committees present their proposed bill, and then the two from Panama will try to meet with the two from Arcoma. I will be here available for any group to talk to me. And I will, what I will do that will be posted Monday will be kind of a timeline, because I don't think I've done that yet. Yeah, so I'll have a timeline posted. It'll be underneath this discussion assignment. So that way you'll have kind of a structure to go by. But yes, we will discuss it in class. Is the module 4 on the screen?
No.
No? Okay. So is it still this one, the court system?
Yeah.
Okay. So a quick little review. There are how many justices on the Supreme Court?
There's one.
7, 9, or 11?
9.
Oh, it was 9, yeah.
9. Yep. Do we elect these justices?
No.
No. The president appoints them, the Congress approves them or rejects them. Are they confined to, for example, 2 terms like the president, or 4 years or 6 years?
They get as long as they retire or die.
Right, they are there for life. All right, very good. Was there a question?
No.
Teachers, could you please release the cheerleaders to head to the gym, please? Thank you.
So we ended by talking about how someone or a party gets the Supreme Court to review their case. A petition for the writ certiorari. The Supreme Court only hears about 10% of the 8,000 requests that they get a year. When it comes to a decision being made on a case, while the decision is important, of course, for example, Obergefell versus Hodges in 2015, legalizing same-sex marriage. That was a decision. What is more important are the opinions. The opinions. What this basically is simply the court explaining their legal basis for the opinion. There are basically three types of opinions. You have the majority opinion, which basically is the winning side. So if we go back up here, wrong way, sorry. If we go down here to Obergefell versus Hodges, Obergefell, the 5 judges who voted for it, they are the majority opinion. You can see here page 1 of Obergefell versus Hodges, which, by the way, it's 103 pages. Page 1 here says opinion of the court. We're going to look at it here in a little bit. Now, you noticed here, then there's a dissenting opinion. This is the opinion of the judges who voted against it. So this would be these 4 men. And as I will show you here in a little bit, the opinion of these 5 was about 27 pages. These 4 and their dissenting opinions took up about 50 pages. So there was more pages of dissenting opinion. In other words, giving the reasons why they voted against it. Now, why? And then you have a concurring opinion, which is better shown in this graph here. A concurring opinion is basically, well, it's got 2 parts, and this is all on page 419 and 420. So for example here, this one would show a 5-4 decision. But what a plurality opinion means is that while there were 5 judges who voted to uphold a law, in this case, one person did not agree with the legal reasons. So they still voted for it, but they did not agree with these 4 and all of their reasoning. So the 4 that agreed, that's the plurality. That's the group, the plural, instead of singular. Now, when we come down here, excuse me, when we come down here to the concurring opinion, this person now is highlighted here, and they have to write their own opinion of where they have disagreed with these 4, even though they all passed the law. Now, I know that it's probably a little confusing. Any questions on that?
No.
And then, of course, the dissenting opinion are these 4 people here. They all voted against upholding the law. So, but for test purposes, you just need to know the majority opinion and the dissenting opinion.
What was that? It cut out a little bit.
You just need to know the majority and the dissenting opinion for the test.
Okay.
The majority opinion is the official court opinion. The dissenting opinion are the justices that disagreed with the ruling.
And you said that's in the book?
That is in the book on 419 and 420. So just as a visual, again, in this very landmark case, here's the 5 who are the majority opinion, Here's the 4 that are the dissenting opinion. Let me move now to the actual case online, and I can find it here, show you what I'm talking about. Okay, do you see this website, the Supreme Court? Okay, this is the official website of the Supreme Court. So you can go here. This is the home page. Then you can click here on opinions, and it'll bring a drop-down menu. And if you go to opinions of the court, it'll then give you year by years. And so for some reason, Obergefell versus Hodges was in 2015, but I had to click on 2014 to get to it. And so here is the official ruling. You can see up here at the top, 103 pages. The first 5 pages are the syllabus. You guys are familiar with the syllabus. In other words, it's just a little bit of a summary of what's going to be in the remaining 98 pages. So we get through the syllabi, and now we are at the opinion of the court. And then if you look down here at the bottom, Justice Kennedy delivered the opinion of the court. And he began by writing, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity." And then you're going to have sections on this in this opinion. Section 1, 2, and then subsections, and this is going to go on for 27 pages. Yeah. Now, something that I teach as a pastor is because I hear people in my congregation saying, well, we lost rights when this passed. But on page 27 here in section 4, they concluded by saying that those who do not agree with same-sex marriage did not lose their rights. They can still share their teachings, and they are protected by the First Amendment. So just a little plug there that I wanted to share, that what these kinds of things include. So there is the ending of the opinion. It was basically 23 pages. And then you have 5 pages of appendices, which basically is, think about your reference page or your works cited, or if you do a long paper, you might have to have an appendix. But then we get to the dissenting opinion. And you see there, CJ, Chief Justice Roberts, dissenting opinion. You come down here, Chief Justice Roberts, with whom Justice Scalia and Justice Thomas join in dissenting. And then he begins his dissenting opinion. And it goes on for a while. A long while. Okay, so it went to so it was like 28 pages, just him. Then you have Justice Scalia giving his dissenting opinion. And then you have the same with Justice Thomas and then Justice Alito. And theirs goes all the way to the end. So that is just an example of a Supreme Court decision. And the reason I wanted to highlight why the opinion is more important, and the textbook makes this case too, is that if any of you are going to go into law school, for example, you want to become a lawyer, you will be studying previous cases, and especially you will be reading about the opinions of the judges. That is how, and not only will law students be reading them, historians will read them, political scientists will read them. So that's why it's so important. So just for the test purposes, know what the majority opinion is and the dissenting opinion. Any questions? Okay, there are two types of disputes that our courts deal with. You'll need to know these also for the test. And in our textbook, they are on page 423 and 425. You have criminal law and you have civil law. Criminal law basically are crimes that are against the public, that are a threat to freedom. Someone who is brought to court for a criminal prosecution has the right to have an attorney, even if they can't afford a private attorney. The government will appoint an attorney for them. And then they also have a right to be tried by a jury of their peers. Civil law is more about relationships between individuals and their legal rights. So probably the best example is to think of a man and woman getting a divorce. That is a civil law dispute. The criminal law disputes, the decisions can end up meaning jail time, or in the case of murder crimes, the death penalty. Civil law, the only type of reparation is monetary punishment. So in other words, the person who loses the case has to pay money to the winner. That's the only type of punishment. So here's a good example to illustrate this. About 7 or 8 years before you were born, there was a major event, crime, court case with O.J. Simpson, who was a former football player. In 1994, his wife and a friend of hers, which they believe was a boyfriend, they were found murdered. O.J. and his wife were separated at the time. They weren't completely divorced, or legally divorced yet, but they were separated. If you haven't studied the O.J. Simpson case, there was all kinds of evidence to point to him, but he was found innocent in a criminal trial. So he didn't go to jail. It was in California, so he wouldn't have got the death penalty, but he did not get any kind of jail time. He was found innocent and set free. So the young man who was killed, his name was Ron Goldman. His parents, or his dad and his sister, they took O.J. to court for a civil trial. He had been proven innocent criminally, but in the civil lawsuit, he was found guilty. And he had to pay, he was ordered to pay the Goldmans, I don't know, a few $1 million. Which, if you ever watch an interview of those people, they did not care about the money. They just wanted to hear somebody say OJ is guilty. Now, what was interesting about a civil lawsuit can also be tried by a jury, but where in the criminal law case, you have 9 jurors and all 9 of them, or is it 10? I think it's 10 or 12, sorry, 12. Duh. You have 12 jurors. All 12 of them have to agree this person is guilty, this person is innocent. So with the O.J. Simpson trial, all 12 jurors said he's innocent. You cannot have a 10-2 decision or a 9-3 or an 8-4. If you do, that is called a hung jury, and the case is labeled a mistrial, and they get a new jury. So it's 12-4 or 12 against. In the civil law case with OJ and the Goldman family, you don't have to have an absolute majority. Now, I think the civil case was 9 jurors, and I think they voted 6-3 that he was guilty. So that's the best way, I think, to illustrate and explain the difference between these 2 lawsuits or disputes. Any questions?
No.
All right, so we talked about on Wednesday that the court system is a little bit different than the presidential or the executive branch, as well as the legislative branch. Judges are appointed for life, and while they can technically be impeached, it's pretty rare. And because they are in the branch that is about judiciary issues in the law, they have made a commitment to be as unbiased as possible, to be objective. And so they don't really have, I mean, while the executive branch and the legislative branch can exercise some constraints on the Supreme Court and the judicial system, it's not that substantial. But there are some other constraints that are put upon the federal law system that are basically boundaries to help the Supreme Court, as well as the lower federal courts and then the state courts, to faithfully apply the rule of law. That's what our courts are all about, applying the law and keeping personal opinion and political party divide out of the decisions as best as possible. So here are the constraints. Of course, the U.S. Constitution has laid out in Article 3 what the Supreme Court and the federal courts can do. And this is on pages 430 through 433, if you want to follow along somewhat. There's a nice little table on page 431 at the top that has these first three right here. So the Constitution has laid out the boundaries for the Supreme Court, but that was written 240 years ago, and it's a bit vague. So the Supreme Court, as best as possible, trying to be objective, will apply the law, apply constitutional boundaries in light of present circumstances. But there are some other laws that are a constraint that will keep the Supreme Court and other federal courts from having too much personal persuasion on these decisions. For example, there are what are called statutory law, or is statutory law or legislative law. You can see there in your book that these are regulations or laws that were basically created by Congress. Remember, Congress is the lawmaking branch. So they have set up, and I have another one down here for us to look at. Here we go, yeah. Statutory law is written law formed by the legislative branch or Congress. It's different than administrative law, which is from the executive branch. Or, and you don't have to know this, but common law, which is by the judiciary branch. Statutes can be created on the federal, state, or local level. For example, you guys remember that really old movie from the 80s called Footloose?
Yeah, I don't.
Even though it was remade a few years ago, I refuse to watch the new one because, I mean, the old one has Kevin Bacon in it, and you can't beat Kevin Bacon. Anyway, that was based on a true story, not exactly the same state, but it was based on a town in Oklahoma that had made a law that there would be no dancing within city limits.
That was real.
That was real. Do the Google of it and you'll see. You know, get on the line and you'll find out. Now, what's that what movie is that a reference to?
I didn't hear you. There's an announcement.
If you get on the line, you can Google it. On the line.
Oh, is that a Footloose reference? I don't
No,
know.
it was the internship with Owen Wilson and
That dark-haired guy.
yeah, he's the guy who said it. He kept saying that, and he was driving those millennials crazy. They kept saying online, online. He would say on the line, on the line. Anyway, this city in Oklahoma, this little town, had passed this law, and it wasn't because of a moral reason like dancing is evil. I think there had been some teenagers killed because of drunk driving, and they had been out dancing at a club, and then they were drinking. So that's why they passed it. So that was a local law, right? Local, but it wasn't a state law. The whole state of Oklahoma had not made it against the law to dance. So, but if you look here, statutes of lower jurisdictions are subordinate to those of higher jurisdictions. If Oklahoma did want to make a law that said dancing is okay everywhere in the state, then that little town would have to drop that law. So the higher the court, as far as level of government, it takes precedent to the lower jurisdictions. That's why when we go back to this court case here, in 2015, when this passed, there were still some states that same-sex marriage was illegal in. Well, because the Supreme Court passed it, and that's a federal court, therefore it became legal in all 50 states. So anyway, statutory laws are laws that are made by legislatures, and they can put restraints on the judicial system. I'm sorry, you will need to know about common law. Sometimes it's called case law. In our book, you can see there at the top of page 431, it is called precedent. Precedent, which simply means that if another court has ruled on this same issue or something very similar to it, and they have set a precedent, then any cases after that court case will need to take into consideration the previous case that set a precedent. So let me try to think of an example here. Oh, in murder cases, for example, a lot of times the defense lawyers will make a plea of my client was insane, right? The insanity plea. He didn't know what he was doing, or he didn't premeditate this murder. He basically, in a fit of rage, became insane. And in considering that, the judge will have to make a ruling if this is something that can be allowed into the legal process. And the judge will take into account, okay, previous court decisions where someone was set free because they were found to be insane. So that's what precedent is. And so that's why law students have to study previous court cases to see how the court system in the past came to decisions. It's on page 432. And there's a good line in the middle of that second paragraph. If courts routinely ignored how similar cases had been decided in the past, they would create confusion and uncertainty about what is lawful and what is not. And then this is not mentioned in the little table on page 431, but it is found at the bottom of the page in the paragraph. Administrative law is based on statutory law. And remember, it comes from the executive branch, but a lot of times it comes from some of those government agencies that are in the executive branch jurisdiction. So for example, if the Environmental Protection Agency passed a law that this is just something crazy off the top of my head, you can only use a certain hairspray 3 times a month because it emits too many fluorocarbons, which kill the ozone layer. If that company that makes that hairspray wanted to make a similar hairspray, they would have to consider this law that's already in effect. I know that's kind of a bad example, but hopefully that made sense. It would be a administrative law that has a regulatory function. And if a case like that ever got to the Supreme Court would need to consider the statutory law, and in this case, it would be a regulatory law in making their decision. Man, that was a poor example. Anyway. All right, any questions on that before we cover this last section quickly?
No, sir.
This is pages 437 through 443. We are talking about the power that the Supreme Court, I'm gonna just use the Supreme Court right now as an example. We're talking about all of the judiciary branch, but specifically the Supreme Court, the power that it exercises. And at the top of page 438, a major concept is that of judicial power. Oh, I'm sorry, judicial review. Judicial review is the power of the court to review any law and make sure that it's, to determine if it's constitutional or unconstitutional. And whatever they decide, for example, if they say it is constitutional, then they will say the law should be enforced. If the law is unconstitutional, then the law will not be enforced. So back to our example case that we've been using. When the Supreme Court heard this case, there were 20-something states that had outlawed same-sex marriage. So in this decision, they ruled that it was unconstitutional, and therefore those laws could not be enforced any longer on the state level, and it became a federal law. So that was an example of judicial review. They reviewed some laws and ruled them unconstitutional. Can that change? Or, for example, can the 1973 ruling of Roe versus Wade that made abortion legal, can that be changed? Yes, it can. Only if Congress were to pass a constitutional amendment, or if a Supreme Court later modified the decision. So yes, they can't. So yes, a Supreme Court decision can be changed, but it's not. It's pretty rare. So the Supreme Court has the power to review all laws to see if they're constitutional. Now, there are basically two thoughts of belief about how the judicial review is, how it's basically applied. Those who are more on the conservative side say that a lot of times the Supreme Court is guilty of being activists. In other words, they are, in essence, using their power, they're abusing their power, and they are basically superseding the lawmaking function of the Congress. For example, on the state level here in Oklahoma, at one time we made a law in the state of Oklahoma that outlawed same-sex marriage, but in 2013, our state Supreme Court overruled that. And the reason that was a big deal was because the voters in Oklahoma voted to outlaw same-sex marriage. And then the state Supreme Court, 9 justices, actually it was a 7-2 vote, so 7 Supreme Court justices completely overturned the majority vote of Oklahomans in 2013. So that's why it's called activism. 7 judges basically said over 60% of Oklahomans who voted to outlaw it, their vote does not count, or their vote was unconstitutional. Does that make sense?
Mm-hmm.
Activist judges, supposedly, this is what conservatives will say, judges who are activists supposedly are eager to overturn congressional legislation, or they are eager to further their own policy goals. They are accused of making law instead of interpreting law from the bench, but that really is not true. They are, and I'm a conservative, and I would be for, you know, a law that says same-sex marriage is illegal. Now, I would not be opposed to same-sex couples having what's called a civil union. My issue is that they call it marriage. But anyway, I don't believe our judges were being activists. I think they were trying to apply the law as best as possible. And then the other side to this is judicial restraint. This is what the more liberal side says. They accuse judges of, you know, they're not being activist enough. They need to exert their power more. This is what conservatives like. We want judges who will basically pay close attention to what previous rulings have made. And if there are any changes, they should be incremental. That is, they should be little bitty steps at a time. If we change something, it should not be a big major change all at once. So any questions on those things?
No.
You'll want to know judicial review, judicial activism, and judicial restraint.
Okay.
All right, have a great weekend. We'll see you on Monday.
All right. Thank you. You too. Bye.
Bye.